Thank you.
Thank you.
Thank you, Senator Oban and members of the committee. My name is Flint Stebbins. I am an attorney for parents in dependency cases in Snohomish County. I'm here to testify in support of SB 5363 concerning the appointment of counsel for youth and dependency court proceedings. The American Bar Association also supports this bill.
Can you move the mic just a little closer if possible? Thanks.
The American Bar Association also supports this bill, and materials will be provided for the record reflecting that. There's no question that the lives that are most affected by these cases are the children's, and paradoxically, it is the children alone who are not assured the protections provided by legal representation. This weekend, at airports across the country, we saw the power of legal representation and have been shown how forceful and immediate such aid can be to those in need. As a parent's attorney, I am limited in my ability to argue on behalf of a child who is not my client. I can argue that a child is expressing a desire to be returned home, but such arguments are often given little weight as they appear self-serving, and there is little basis for the parents to know a child's feelings because parents are typically prohibited from discussing the case with their children and are often punished for doing so. For similar reasons, counsel for other parties cannot be relied upon to protect the legal interests of children or the child's expressed goals, whether it be for a return home, being placed in foster care, whether they can be compelled to testify, or on any other issue. ACASA is generally not trained in the law, and their responsibility is to advocate for what they believe is in the child's best interests, which can often conflict with what the child wants. Expecting ACASA or any other party to advocate for a position with which they disagree offers no meaningful protection at all. If a child has a question regarding legal advice, they literally have no one they can go to for that. When a party is not represented in litigation, the only reasonable expectation is that their rights and interests are not being fully protected. This means that in every case, in every decision by a court, there is a likelihood, not a chance, but a likelihood that the child's legal interests have neither been completely identified nor presented to the court. For those reasons, I ask for your support in passing SB 5363.
The question, if this bill were to become law and counsel assigned to all children in foster care, what would be the need for CASA in your judgment?
The role of CASA would be to advocate for their view of what's in the child's best interest. That is their role. That would continue to be their role. Sometimes children's desires might be contrary to their own interests, which is what exists now and which is what leaves children now, I guess, in a void where their desires are not being expressed. CASA can also provide opinions about well, you know, actually, I think probably it's best to let CASA respond to that. My expertise is in what the legal profession can provide.
Okay, just since you've been in that world, I just thought you might have some comment.
Sure.
Any questions? All right, thanks very much.
Thank
we'll
you.
hear from the next